Well, good afternoon. And can I start by formally welcoming all of you to this afternoon's interactive international webinar on which we're going to be looking at what's changing for those of you with businesses based in the EU as a result of the International Whistleblowing Directive. And obviously, because this is an international issue, I'm delighted to be here with a number of my colleagues based in Taylor Wessing's European offices. As a start, I'm Helen. I'm Helen Farr. I'm a partner based here at Taylor Wessing's office in the UK, in London. And I'm going to introduce our team. I'm going to start with Marcus Assoff, who is based in our office in Paris, in France. So, Marcus, I don't know if you just want to quickly say hello.
Bonjour. Hello from Paris.
Hello. And then move to Wolfgang Kapek, who is based in Vienna. And he is also the head of our offices in CEE.
Hello, it's me.
Hi, Wolfgang. Rose, who's based in Rotterdam in the Netherlands, who's a senior lawyer there.
Hi, good afternoon.
Hi, Rose. And last, but absolutely by no means least, I would like to end with introducing Jan Patrick Vogel, who is based in our German offices and is a partner over in Germany. Hi, Jan.
Hello, everybody from Frankfurt in Germany.
Hi to Frankfurt. It feels slightly like the Eurovision Song Contest, doesn't it? But anyway, great way to start, I think.
We don't have 0 points.
I know, exactly. So but we'll see how that goes. Now, today, the objective is to have a really interactive session. And what we're going to be doing is discussing the impact of the EU Whistleblowing Directive between us and in line with the impact in our respective jurisdictions. So what are we going to be looking at today? Well, we're going to start by me giving you a whistle-stop tour of what's changing. It really is a reminder, because I'm sure lots of you will be familiar with the key points. But then we're going to move to a panel discussion about looking at 3 key areas between us. And the first is, how should your business prepare for these changes? What do we suggest that you do? Secondly, what steps should you implement to protect your business? And finally, if and when a whistleblowing complaint comes in after this new directive has been introduced, how should your business respond? We do really want today to be absolutely as useful for you as possible. So please do, if you have a question, please do put it in the chat box, and there will be time at the end to deal with questions. So please do put questions in the chat box. It'd be great to hear from you as we're going along. So I'm just going to start by saying, well, why has the EU focused on whistleblowing, and why is it so important? Well, I think the reason why the EU is focusing on this issue now, there's a number of reasons, and I've put the sort of bubbles on the slide to introduce some of the ideas about whistleblowing. But the main reason is that whistleblowing is so incredibly important in revealing wrongdoing and within businesses. And as a result of that, it's been decided at an EU level that there must be minimum standards established so that whistleblowers are protected if and when they make a protected disclosure, and so there's no barrier to anyone from reporting concerns. So the key question I know lots of you will be concerned about is, when is the Whistleblowing Directive coming into force? Well, on the 17th of December this year, so 10 days away, the Whistleblowing Directive has to be transposed into your national laws. And as I've said, the objective is to set a common minimum standards across the EU. The starting point is that for those of you working in businesses with more than 250 workers, the directive's provisions are that the whistleblower that it will be transposed and come into force from the 17th of December this year. But for those with workers between 50 and 249, that comes into force in 2 years' time, in 2023. So there's a little bit of time if you have less than 250 workers to plan. And the key points to stress from that are that it applies to workers, which is a much broader category than just employees. And of course, it applies to breaches of EU law. And interestingly, the directive only applies to certain areas. So not all areas of EU law will be covered by the terms of the directive as drafted. So, for example, public health, privacy breaches are covered, but each member state has the option to extend the protection if they want to other areas of EU law. So it's not a completely exhaustive list. So what are the key requirements of the directive? Well, I think the really interesting point that lots of our clients are asking us about is this requirement that you will be expected to introduce an internal reporting channel, and it has to be secure. And importantly, you have to make sure that you maintain the confidentiality of the whistleblower. Whistleblowers can also, they're allowed to report directly to national or EU authorities. And there's public reporting too, and that would go to the media or a wider public disclosure. It's really important that you do keep the whistleblower updated and maintain his or her confidentiality, and that's directive requirements. And there's also protection for from detriment built into the directive. And the directive allows each member state to introduce remedies and penalties if there's a breach. And I think as a result of that, we're all going to see a lot of challenges for businesses arising from the directive. The first is, for those of you with a number of offices across Europe, you're going to have to consider, how do you harmonise your practice? Do you level up? So do you bring everyone up to the same standard, which may be easier to operate, but do you keep different processes in each of your countries where you operate? How do you establish the secure internal reporting channel? What steps do you need to put in place? What steps should you take to educate and train staff about the directive? How do you make sure that the whistleblower's confidentiality is protected? And finally, what should you do about introducing new policies and procedures? So I think there's lots and lots of issues to think about. And I'm going to now move to our panel, where we're going to have a discussion about how to prepare for the changes, which is the first part of our discussion. And I'm going to start by firstly asking a question to Rose, who's based in the Netherlands. Now, Rose, I've explained that the new directive requires businesses to set up internal reporting channels, but it also allows employees to report, make disclosures externally, so to the media, to the press, or to a member state. Now, obviously, that's kind of difficult for businesses to manage, because ideally we would want the disclosure to be made to the business so that we can deal with it first. What do you think about that? How do you think businesses should manage that challenge between the requirement that people can report internally, but can also go externally if they want to do so?
Yeah, thank you, Helen. You're correct. Whistleblowers can immediately report externally, and this is a change in legislation, at least in some countries, for example in the Netherlands, and I know it's the same in France, because there's currently still the obligation to report internally first. Now an external report can be made to a competent authority, which is included in the local laws. A whistleblower may also make his report public under circumstances, for instance to the press. And this change in focus may indeed result in employees going straight to external authorities. But it's good to be aware of the fact that this is not the purpose of the directive. The directive includes that all the different jurisdictions shall still encourage whistleblowers to report internally, at least at first hand. So we do expect that there will be a focus on companies trying to make those internal mechanisms as attractive as possible, because internal reporting is, under a lot of circumstances, still preferable. If a report is made internally, alleged violations and abuses can be debunked in a timely manner, and legitimate reports can be addressed directly at the source. But this, however, requires that there's that the internal hotlines the companies have are accessible, secure, and responsive. So this means that also the feedback, for example, reporting what has been done and why should be accurate as well. And besides that, it's an absolute requirement that the company has an open and accessible culture where dissent is embraced and not punished. So employees and other reporters shouldn't be afraid to make a report, and management shall also openly support the whistleblowers policy and the practice. So those are really important things to keep in mind. Wolfgang, I've heard that Austria has some specific regulations on internal reporting. Can you tell us a little bit more about that?
Yes, thank you, Rose. I mean, it's, there are some specific rules on the internal reporting, but most of all in Austria and also in some other countries, there are already several laws which allow criminal sanctions or fiscal penalties to be reduced or even completely avoided if the company approaches the authority or the regulator first before they get any knowledge about any wrongdoing. And that's why it's really critical for a company to get in any complaint about such wrongdoing before the employees turn to an authority and use an external channel. Because if they can get hold of the information and then can go to the authority, approach the authority themselves, that something hasn't been done correctly, then they might get out of any sanctions or fines. And that's very important here. And it's simply too late if someone has already approached the authority.
Thanks, Wolfgang, and thanks, Rose. I think that's really, really interesting, and it does show, I think, the practical problems that we're going to have to manage between these two routes that employees can potentially take. But I think, as I said in the introduction, Wolfgang, the directive only applies to specified EU laws or rules. But the EU is obviously given a message that it would encourage member states on an individual basis to extend that protection. So how do you think companies should respond? So obviously if they get a complaint through that is a broader category than is technically covered by the EU directive, how do you think that they should deal with that complaint?
Yes, Helen. I mean, first thing will, of course, be to take a look at the local laws. There is a discussion going on if they will provide for a broader scope than the EU directive, what would make sense in many issues, but we will see. There's even a discussion in Austria to include at least anti-corruption, but again, we will see how this develops. And then, of course, it's up to the company to decide how to deal with other issues. First thing, if they open their internal channels also for other issues, and even if they don't, you have to expect some complaints, some notifications on issues you have not in your scope. You did not think that they would come, maybe. But I would say that you are on notice of the issue, and so you can't simply ignore it and say that's not covered by the scope. Specifically, it might be a severe issue, a severe wrongdoing or misconduct of someone. This will, of course, need to be investigated and managed. I would say in the same sense as if the company would have gotten knowledge of it in any other way. And so you really need to be aware of this and then take the appropriate steps to handle these issues once they come in. But Helen, I mean, there is already a well-established legal framework in the UK for the protection of whistleblowers and the handling of notifications. What do you see as the key differences between your system and the EU, and most specifically, what have UK businesses with a presence in the EU to be aware of on such differences?
Thanks, Wolfgang. Well, I think that's right. I think for those who are based in UK businesses but have a presence in the EU, they do need to be aware that, yes, in the UK we've had a system in place for nearly 20 years now, but the UK focus is very much to protect the whistleblower against detriment. And the EU, the new proposed system, has two purposes. One, it's to protect the whistleblower, but it's also to ensure that there's a proper system for dealing with the whistleblowing complaint. And so there's a number of new procedural requirements that you're going to need to introduce in mainland Europe that will be different to those that you're familiar with in the UK. And the first is obviously the key difference is this need to put in place an internal reporting channel, because that's not the case in the UK. And because the UK is not implementing the Whistleblowing Directive, that won't be an English or UK requirement. Although I do think, and I would suggest that if you do have an international operation, it would be good, I think, to treat all employees in the same way and to put in place that kind of internal reporting channel for employees based in the UK too. The other difference relates to confidentiality. So in the UK, there's no sort of legal requirement in the statutes that mandates that you have to keep the whistleblower confidential, although there's been a lot of sort of case law on that. And certainly, I think best practice in the UK is to ensure that that happens. But it's not an automatic breach of any legal requirement in the UK. There's also no requirement in the UK to give feedback to the whistleblower, which again is a requirement of the directive. And finally, there's no record keeping requirements either. So I think there will be a number of different procedural changes that we do need to be managing to make sure that businesses are in line with the directive and that there's a consistency of approach. But Marcus, I think moving away from procedural matters, what's your view on the impact that the directive will have about sort of culture around whistleblowing? Do you think it's going to make much of a change in that sense?
Perhaps from the French perspective, you have to know that since 2017 already, all companies in France with at least 50 employees, so 50 employees have an obligation to implement an alert system. And the scope, what was discussed, is very large. So therefore, I think probably the European directive will not have a specific impact on this. But what is interesting in France to see during the last years, that historically speaking, there is still a little bit a culture of negative perception that employees could not or should not raise any issues or say something or anything negative about their colleagues. This seems to change during the last years because companies and also employees understand more and more that a whistleblowing system is at the end a protection for the company, its reputation, financial, economic interests, but it's also a protection for the employees. So therefore, I think in order to accept these kind of alert systems, it's important that the communication, that you have the right communication in place, that you have training, awareness, so that you start to change the mindset that whistleblowing, to say something is not negative, is to protect the company and to protect him or herself.
Yeah, thanks. I think that's a really, really valid point, and I think it's really important about protecting the employee too. Just from a practical perspective, and in line with the discussion about preparation, yeah, and I know that a lot of our clients have with pan-European operations are going to be looking to engage with social partners. So by that I mean trade unions or work councils. Are there any particular issues that you can see with that as part of their preparation?
Thank you very much, Helen. That's a very good question. When it comes to Germany, I think the main reason from an employment law perspective is that if you do implement whistleblowing systems to your organization and to your company, then it's very likely that the Works Council, if you have a Works Council, has a so-called right of co-determination. That means that you have to discuss with your Works Council your whistleblowing system, and you need to find the consent of your Works Council to that whistleblowing system. And if you don't have that, you are not legally able to implement the system. So theoretically, your Works Council can block such a system and refrain you from complying with regulatory issues. So at least from a German perspective, it is important to approach your Works Council very early to discuss with them the issues, because normally Works Council, they shouldn't have anything against the whistleblowing hotline because it's a compliance issue. But what they often tries to discuss is they link it to different topics. So it's a good idea to be open and to discuss with your Works Council on a very early stage the processes and the procedure of the whistleblowing system.
Yeah, no, I think that's right. I think that's really good advice. I think you do need to make sure that you do either get trade unions or work councils involved and at the earliest possible point. Now, Wolfgang, one of the questions that we all have is about, timing for this, because we need to know, we need to prepare, we need to get ready, and we need certainty. And the position is that in each jurisdiction, we still don't have a final version of the regulations. What's your sense of that? Do you have any indication of when each jurisdiction will implement the changes and how much time businesses will have to get ready?
That's a very interesting question, Helen. I mean, we should ask the government because it's really somehow strange. We have December 7 now, so people would have 10 days, and the EU directive says for companies which have 250 or more employees, this is the decisive date to implement also the internal channels. And as far as I can see the various drafts so far, this means 250 employees per legal entity. So it's rather going on an entity basis and not a group on the one hand. On the other hand, most drafts stipulate that smaller businesses will have time until December 2023, as you already said in the beginning. And so far in Germany and Austria, I think we are all struggling to get governments in place and do not concentrate that much on the draft of the whistleblowing laws. There are only internal drafts which were leaked the one or the other way. Austria still seems to stick for the bigger companies with January 1, but I think it's not realistic. I mean, in France, the Netherlands, UK and Slovakia, there are already existing schemes in place. So I believe that employers there will not be that much surprised by it. But even in other countries and other CE countries, laws are still to be passed. Sometimes they were rejected and so on. I mean, we know that Sweden has already implemented a law saying it's July 17 for the smaller companies, 2022, and giving also time for the smaller ones until end of 23. So I think middle of next year would seem to be a good approach, even if not completely in line with EU law. But as I said, Sweden already did it this way. Yeah, we might be looking forward to get some practical solutions from our governments and parliaments and whatsoever, because at the moment there is still a chance that companies with 250 or more employees will need to do it in 10 days.
Okay. Yeah, I think that's really helpful, because I know I've certainly had a lot of questions from clients asking me about, when do we need to get this sorted? And it's so difficult when it's just not clear, is it? It's very difficult. I'm going to now move on to our next section, which is about how to protect your business. And my next question is also for you, Wolfgang, which is about the need for internal reporting channels. And I think one of the questions that we're all concerned about is where you have a number of operations across Europe, do you need to put in place one reporting channel in each country, or is it okay to have one reporting channel that would apply everywhere across Europe, and maybe even the UK too, if you wanted to?
Yes, I mean, in principle, this has already been discussed between the Commission and some of the member states, where the Commission is a little bit reluctant to allow a group solution or a solution for groups of companies if there are more than 250 employees in the respective legal entities. There are already different laws in place. For example, Denmark made a privilege for group companies. Looking at the Austrian draft, there would not be something like this. Even for smaller companies, the let's say unofficial leaked draft of the Austrian law would oblige smaller companies, if they share such internal channels, that this must end in Austria. There was already a discussion on this, because people here say, please do it in a way that's practical, because it doesn't really seem very practicable if every company, even in groups, needs their own channel and their own internal responsible persons to deal with it. But however, and unfortunately, we still have to wait for the laws to be passed and see what the solutions will be. And I think the most disturbing fact is that it seems there might be different solutions in different EU countries, which is rather very problematic from a pragmatical point of view.
Yeah, I think that's going to be really difficult, isn't it? Because if there is a different solution in different countries to that issue, we may be forced to have individual reporting channels, even if certain member states are taking a more pragmatic view. So it's difficult it's going to be difficult to balance that, I think. And I know lots and lots of people, lots of clients are really interested in sort of certainly in the question of protecting their business, about the question of policies and procedures. So what policies and procedures do you think would you advise your clients to be thinking about now to get ready for the directive? Oh, are you there, Jan? I don't know whether Jan's there or not. I think he might have disappeared. I'm going to move on to Marcus, and then hopefully if Jan comes back, I'll ask him that question. Marcus, another question is about training. What steps would you advise in terms of offering training to staff?
I think you're on mute, Marcus.
Sorry.
Thank you.
So I'm no longer unmute, so thank you, Rose. So what I already said, from French perspective, we have already a law in force since 2017 with clear guidance on this, especially for bigger companies with at least 500 employees and a turnover of more than 100 million euro. They must set up a specific training program for its employees. But however, we recommend, of course, clearly that training should be put in place or set up for all employees, whatever the size of the company is, also for the smaller one, especially for the smaller one. Because, of course, awareness, information, communication is key to have an efficient whistleblowing system in place. And I think it's also important to give clear guidance with concrete examples of bad behavior. For example, what we try to do is examples of case law from competitors, the same industry area, that the employees can see it can happen because it happens to a competitor. And so we also offer sometimes small videos so that you can get this a little bit more alive, and that they can see, okay, yeah, things could happen, and bad behavior is clearly defined. And in this regard, of course, it's I think also important that the tone comes from the top, that the management is not only supportive with the right communication, because only then you can change the companies and the employees' mindset. And perhaps one point also to compare to Germany, as Jan said, of course in Germany the Works Council, or they have a sort of veto right. In France, not. Of course, therefore it's a bit easier, but you have to inform each employee individually of the alert system, and this is in a certain way the beginning of a sort of information, and then the training program should follow in a certain way.
Thanks, it's really helpful. And I think I think that actually raises a bit of a follow-up question, I think, to me, which maybe Wolfgang you can help with, which is, I think Marcus was very clear that it's really important, obviously, to undertake training. But of course, training is only going to take this issue so far. And unless management are supportive of whistleblowers, do you agree that without that management change, there won't really be any meaningful change?
Yes, I completely agree. Specifically, I would say here in Austria, where we do not have a real history of whistleblowing, and also in other CE countries. I mean, I remember some weeks back we talked to a compliance officer of a bigger Austrian company who had to adopt such a system some years ago, and he said when the first notification came in some years ago, he went to the CEO and said, "Oh, there is a notification coming in, so we have an issue." And the reaction was, "Who did this? Who wants to get fired?" It was not what it is about. It was just getting rid of the whistleblower. He's no longer the CEO there, by the way, but that's a kind of reaction we came across when the first talks came about whistleblowing, saying that we do not need this here. We have everything under control. I think as Marcus said, it needs to come from the management as the tone from the top, and otherwise things will not change. And we have already discussed how important it is to get this internal channel really going.
Yeah, no, I completely agree with that. And I think, Rose, another question that a lot of people have been asking is about, can businesses introduce one policy to cover, all of the jurisdictions, one sort of whistleblowing policy, or do we again need to have a separate policy in each country? What would be your advice on that?
Yes, thanks, Helen. We often do see or have a lot of questions from clients who wish to have one policy for all their countries where they operate, and that's understandable and definitely possible. It's also recommendable from a consistency perspective, and could also be very practical if the company offers training to its employees, which is a good thing to do. So that it is possible, and we do recommend that if there are really specific regulations for a specific jurisdiction, that you draft an annex, for example, and include those specifics to make sure that in each country you comply with the local legislation.
Can I just ask, Wolfgang, would you have a view about what policies and procedures should be adopted generally, or would anyone else be happy, Jan or Wolfgang, would you be happy to answer that one? And any thoughts about what we need to do as businesses to implement policies and procedures to help resolve these issues?
Yes, sure, Helen. I mean, you definitely need some policies and procedures in place. As Markus said before, also in Austria, you need to notify all the employees about the internal channel, and you also need to inform them about possible external channels. So you still have this competition going on here. And then you need a policy on clarity how complaints are dealt with, and really how to do it. I mean, we know that you in the UK and also in the US, there is very common for companies to have such policies in place. It's maybe not so common specifically in Austria, but nevertheless, they are really needed in order to get things right. And also you need to focus on, you should not only focus on, let's say, the technical issues, how to use this system and so on, but also to think of trainings, for example, what is corruption, what are the issues you should avoid, and what can you really then make a notification on, so that people also get a sense again on the behavior which is needed. And so it really needs a transparency to the employees, first thing, on how to behave, what is an inappropriate behavior, and what should be notified via such systems, in order that the company can react on it, it can correct such negative behavior. And also it's important that you are prepared to have the policies and also the investigation once you get a notification in. So to also have an understanding who deals with it, who is informed internally. Also, in order not to spread the information beforehand, because this very often then leads to an inefficiency of all these investigations. Also, of course, it might be a legal problem if the whistleblower becomes known within the company, but if you can avoid this, but everyone knows that there are rumors going on, then it's very crucial. And then, of course, you also have to think of who shall do the investigations, where your legal advice might come from. Because if you do it beforehand, then you are prepared, and someone who gives you advice should have a good understanding of the company and all the needs you have. Because otherwise, if you start thinking of this, once you have the notification in, then it's really late, not to say too late. And the people, yeah.
Thank you. I think that's really, really helpful. I was going to I've just got to, I don't know if Jan, can you hear us, Jan? I think you may be dialed in. Can you hear me?
I can hear you. I hope you can hear me too.
We can hear you. That's perfect. Thank you. Lovely.
Yeah, perfect. The good old phone is working.
Great. I know we should just stick to the older technology. There was just one final question on the piece about how to protect businesses, which was about keeping records and reports. And I wondered if you'd got any particular messages or thoughts on that question.
Yeah, that's also a very good question, and there is no simple yes or no to that question. I think when you look into the directive, and if you could look into the privacy regulation, then there is a principle that normally you should delete irrelevant reports as soon as possible. However, the report and also the documentation on the investigation can be also useful if you have in trial or in the courtroom, or even if the public prosecutor does an investigation. Because one thing is clear, at least in Germany, if you have a suspicion for criminal behavior in your company, as management team, you are obligated to investigate this report. If you don't do that, then there can be a fine to the company and even to the managing directors themselves. So the documentation within the whistleblowing system and, of course, the subsequent investigation can prove in a court procedure that you have done this investigation in a diligent process. So it should be documented to some extent, but it should always monitored and reviewed whether this is allowed based on data protection issues. That would be my advice to that.
Brilliant, thank you. And I think that's the key issue, isn't it? Sort of balancing the GDPR requirements with the need to keep records to protect the business from a potential fine or sanction. So moving on to our final section, which is about how to respond to a whistleblowing complaint. And yeah, again, I think another question that I've been asked is, does it make a difference if the whistleblowing complaint is not within the scope of the Whistleblowing Directive in terms of how you would respond to that? I don't know if you've got any thoughts on that question, Jan.
Yeah, I think this is more an academic question. I mean, if you have a report in your whistleblowing system internally and it indicates a legal relevance, maybe even a criminal behavior, then you don't really ask, well, is this applicable to the European Union Directive or is it not? Because you will definitely investigate, and the interest of the company is definitely to clarify those suspicions, regardless of whether or not the reports fall within the scope of the directive. So I think it doesn't really matter whether the report is subject to the directive or not.
Yeah, I think that's got to be right, hasn't it? Wolfgang, what would your advice be to someone if they were about to approach an investigation now? How would you suggest that the investigation is managed?
Yes, I mean, important point, as I already said before, is really to think of it before the first complaints and notifications come in, how to manage it. So starting with who shall be responsible for the investigation internally, appoint an independent investigator, might also be an external one or an internal one. Think of, as I already said, legal advice, and that's not because we are lawyers, but there might be some issues coming up, like you find a data breach where you have to react immediately vis-a-vis authorities, or you come to a situation where you maybe have even to make a decision on dismissing someone very, very quickly, or where you have to evaluate whether or not you should approach the authority or the regulator quickly in order to reduce the fines, as we already discussed in the beginning. And then you have to make sure that there is no detrimental treatment towards the whistleblower, because for this you will be fined maybe, and of course that's the whole thing about the directive, because it's for securing the whistleblower's rights. And you really have to make sure also that you can promptly secure evidence, and in a way that then is also usable at court. There might be differences also in respective countries. And then one thing also very important is, specifically in smaller entities, to make sure that these investigation teams and the employees who are investigated about, that there is no conflict arising between them, and also that there is no conflict of interest. So you also have to make sure that not the wrong people investigate the wrong issues. So for all this, one really should be prepared of and also distinguish what could come in, and there might be maybe different people, the right ones, to take a look at it, like internal HR or someone from an internal investigation team, or who else, for different issues. It might be different people's the best one to approach.
Thank you. Yeah, and I think that's a really good advice actually in practice about that, to avoid a suggestion of conflict between the investigation team and the employee who's been complained about, because I've seen those issues arisen in practice, and it's very, very difficult to manage, and it completely undermines the whole process. Now, I think one of the key changes and a really important focus of the directive is to ensure the confidentiality of the whistleblower. And Marcus, what would your advice be to those listening about how steps they can take to ensure confidentiality?
Thank you, Helen. It's a good point, of course, because the whole also at the French Parliament, the debate was about how to avoid pressure on the whistleblower, how to avoid that people don't make any complaints, and therefore, of course, the confidentiality is really important, and therefore, as Wolfgang already said, in the company there should be only a selected and very short number of employees be aware of the identity of the whistleblower. French law already sanctions the non-authorized disclosure of a whistleblower's identity. And I think from a practical way, especially in smaller organizations, to guarantee this confidentiality, what I often see and also recommend is to use an external independent party to manage the complaint. It could be a law firm also, and myself as a lawyer, I manage together with an external digital provider whistleblowing hotlines. So in order to offer sort of integrated solution from the digital side and legal side, to deal with the alerts and to protect the interests of the company. Because the point is, especially in smaller companies, what Wolfgang already pointed out, it's difficult to get an independence and an absence of conflict of interest. This, of course, would be given if you use an external provider. And from the legal side, of course, if it's a lawyer, from the French perspective, but I think also from the UK perspective, you could benefit from the legal privilege of the communication between lawyers and clients. So that, for example, competitors cannot gain access to information. And again, of course, the conflict of interest would not be given, so that you have no pressure from a colleague, for example, who would deal internally with the complaint and the hotline against the whistleblower, or to make sure that some information are not given, or that it's done differently, or how it could be, especially in smaller organizations. So therefore, I think, this practical advice, I think, could be helpful to ensure the confidentiality and to avoid all the difficulties you could have internally. Perhaps you could, I don't know, we have always a debate between, legal privilege, disclosure, France, the UK, but also with US organizations on these questions, how to protect, the client from this perspective, and to give really the add value in this regard as a lawyer.
Yeah, I think that's right. I think that's a really good point. Really good point, Marcus, that, actually it is definitely a good idea to have someone independent managing your internal channel. And that is something that we can do here at Taylor Wessing for clients. But also, I think it's really important to think about the fact that if you take advice throughout the process from a lawyer, certainly in the UK, that benefits from privilege, and that means that it can't be disclosed if there were to be litigation. That privilege probably wouldn't apply if a lawyer was doing the investigation, but it certainly helps with maintaining confidentiality and independence if a lawyer or an external third party is involved. So I think it's a really good point, and something that everyone should be thinking about now, especially given this legal sort of mandatory requirement that you absolutely have to take steps to maintain confidentiality now. Rose, just one final question before we look at the questions, and we've got quite a few questions come in, so please do, if you've got any questions, keep popping them in the chat box. That's great. How often, Rose, do you think we need to be reporting to the whistleblower and keeping them updated, because there is a new requirement in the directive about reporting? What would your advice be to clients on that point?
Yes, regular reporting is really important to have and maintain the trust of a whistleblower. Based on the directive, and specifically in the Netherlands, and I know also in other countries, the employer shall draft a policy which includes how it handles a report. And in this policy, one must include two specific parameters around reporting. And the first is that the whistleblower will receive confirmation of receipt within 7 days after receiving the report. That's the first one. And the employer shall also include a reasonable period of no more than 3 months in the policy after the confirmation of the receipt has been sent. And during this period of 3 months, the employer shall provide information to the whistleblower about assessment and the follow-up of the report. And under some circumstances, this period of 3 months can be extended once by 3 months as well, but only if it's duly motivated. And you could, for example, think of a case that's really complex, or a case where one needs further investigation on the report. So generally, the whistleblower must be provided with information after 7 days, and then after a maximum of 3 months after those 7 days. And this information only relates to the progress of the report and not the conclusion of the report. So that's good to be aware of. The period of 3 months can also be shortened, and you can also include in your policy that you will provide the whistleblower with more information or more often. And generally, we do think this is advisable in order to create and maintain the trust of the whistleblower. Because ultimately, the more transparent you are as a company, the more likely you will understand the legal restrictions of the policy, trust your policy, and therefore speak up. And it's also very important that once the matter is resolved, managers are duly aware of the fact that they cannot punish the whistleblower in any kind of way because of making a report.
Thanks, Rose. That's great. And I think that's a really important point about maintaining the trust of the whistleblower. I was going to ask, there's a question that's just come into the chat box, which is kind of linked to that around maintaining the confidentiality of the whistleblower and preventing disclosure. And a question's come through asking about whether the identity of the whistleblower can be disclosed to the person being complained about or to anyone that you're questioning as part of the investigation, including right of reply defence. Marcus, what would your view be on that point?
I think it's a question of course, if the person would, how to say, there could be two types of course of complaint. The person could say, I'm employee X working in this team, and that his name is already known as from the beginning. There could be also, of course, an anonymous complaint. Then, of course, it's a different treatment. And of course, I would suggest, in order to not to breach also especially French law, that the person in a certain way, you ask the person, the whistleblower, if the whistleblower is okay that his name is given to the other person, of course. But if he would like to keep it confidential, so I think his right should be respected, and in any case not against the volunteer of the person to be identified. Again, all this is around pressure, and in order to keep the people trustful, confident that they give the complaint, that they complain, that they. Of course, the point is at the end of the day around all this is also there's another question about internal, external channel, or internal, that's if they go to authorities or not. So if we have the right system in place in the company, why should somebody go outside? I think if the training is made, if the explanations are given, so therefore, by this way only, I can avoid that they talk to journalists or that they go directly to other authorities. And also, perhaps to keep in mind what we have here in France and in Europe, the alerts are disinterested, so no financial interests. It's of course and this is not the same in the US. So the real threat in a certain way sometimes, especially around corruption and other points, are coming also from outside, where sometimes other jurisdictions consider, okay, if we here in Europe and in each country, we do not our homework in a certain way, they do it for us. So therefore, I think in order to protect the company's interest, even if the European directive, it takes time to be transposed in the different jurisdictions, each company has clearly an interest to start the implementation internally of its business of such an alert system.
Yeah, no, I think that's really, really good advice. So the advice would be you potentially could disclose the identity, but you'd need to get consent. But ideally, you'd really want to keep the identity confidential. And of course, to that question about the reporting channels, our very strong advice would be to really do what you can to have the best reporting channels in place to make sure that people feel comfortable and will go to you rather than going outside, because the last thing you want is these issues getting into the press. We're now at 2 o'clock in mainland Europe, or 1 o'clock in London. So I wanted to bring today's session to an end. There are a number of questions. Some of them we've sort of answered as we've gone through, but for those that we haven't, we will be sending a follow-up to you. And if you've got any more questions, please do get in touch with us. I just wanted to finish with a few takeaway points. I think the first is, it's so important to maintain confidentiality, and that's going to be quite difficult for those of you in smaller companies. So do think about that when you're putting in place your reporting channels and your processes and procedures. And as I've said, as Marcus and I've both said, there is a solution here that at Taylor Wessing we can help with that in terms of helping you with those channels. Secondly, you do have to be really careful about how you manage investigations. As building on Wolfgang's point, there should be no conflict between the investigative team and the whistleblower. And, do take legal advice as you go through, just to make sure that you do protect the business at that point. And it's key to ensure, and I think this goes without saying, that there's no detrimental conduct or treatment to that whistleblower during the investigation, but also after it, because they've made that disclosure. And finally, all companies must have in place clear policies, procedures, and also training of staff now to get ready for this. There should be, the advice I think would be to try your best to have the most consistent approach. And again, the team here would be delighted to help if you've got any questions arising from any of that. So I hope that you found our discussion today really useful. I'm sure there's certainly lots of questions that have come through, and I know that this is something that we're going to be continuing to update you about. If you do have any questions, please do contact us. Our details are on the slide. It's been an absolute pleasure. I hope that you found today really useful. And can I just end by wishing you all the very best for a really happy and restful festive break, and a very successful 2022. And hopefully, there won't be too many problems implementing the Whistleblowing Directive, but we'll obviously keep you posted as things change in each country. So thank you very much. And I think if the team can all say goodbye, that would be great too. So bye-bye. Okay.
Thank
bye-bye.
you.
Thanks.
Bye-bye.
Bye.
Bye.
Thanks for joining us. Thanks. Bye.
Thank you.